what this means now for your family. Will you no longer take your children back to the UK?
I think it's probably too soon to tell.
The room did not erupt. There was no gasp, no raised voice, just silence. And in that silence, Prince Harry's story began to fall apart. It was the kind of pause that lands heavier than noise. A courtroom realizing that a line had been crossed, and there was no way back. In that moment, Harry stopped being seen as a wounded prince and started being treated as something far more dangerous to his own case. A witness whose words no longer aligned. Until then, the atmosphere had worked in his favor. Harry spoke with emotion about life under constant media pressure. He described fear, anxiety, and the damage he said the coverage caused to his wife, Meghan Markle. He talked about the strain on their family and the sense that something terrible might happen if the intrusion did not stop. The emotion felt real. The room allowed it. Sympathy lingered in the air. But courts do not run on sympathy. They run on precision. And that is where the shift began. It did not start with an accusation. It began with a simple question.
Calm.
Polite. Almost procedural. The judge did not ask how Harry felt. He asked what Harry knew. Specifically, when Harry first became aware that the information behind certain articles may have been obtained illegally. Harry hesitated. Not long, not dramatically, but long enough. That brief pause changed everything. Until that moment, the court had been listening to a narrative. Now it was examining a structure. Narratives move forward on emotion. Structures demand alignment. Dates must match. Statements must hold. Written words must survive spoken scrutiny. Harry answered, then answered again slightly differently. The judge did not challenge his sincerity. He did something worse. He started narrowing the frame. The questions became tighter. Less room for interpretation. Less tolerance for general feeling. Harry was no longer invited to tell a story. He was being asked to place it inside a rigid legal timeline. As the questions sharpened, Harry's responses shifted. He became frustrated, defensive, more emotional, less certain. Words like, "I know," quietly turned into, "I believe." Confidence softened into qualification. This is how credibility erodes in court. Not with explosions, but with drift. Emotional strain does not strengthen testimony. It weakens it. Judges know this. Emotion can blur memory, especially when a witness is desperate to be believed. And Harry did not see the danger forming beneath him. That danger had a name: retrofitting. The court moved closer to the center of the problem. Waiting on the judge's bench were Harry's own written witness statements. Carefully prepared, reviewed,
Signed.
In those documents, Harry had been clear. He claimed he knew at the time that the press was acting unlawfully. The language was firm, certain, unambiguous. Now, under oath, without prompts or protection, he was asked to explain those words. This is where everything began to unravel. When pressed on what exactly he knew about the alleged illegal actions, Harry's answers began to shift. At times, he suggested he knew back then. At other moments, he admitted that his understanding developed later, after patterns became clear. He tried to bridge the gap by saying hindsight had sharpened earlier impressions. That explanation does not survive a courtroom. The judge identified the fault line immediately. Was Harry describing what he actually believed at the time, or what he believes now? That question cuts deep. Because belief formed later cannot be projected backward to support a legal claim. That is not evidence. That is reconstruction. The judge asked directly whether Harry's belief in illegality existed then, or only now. Harry landed in the middle.
Suspicion existed, he said.
Certainty did not. But his lawsuit claimed certainty. In trying to explain the nuance, Harry exposed it. His case appeared to be built not on facts known at the time, but on conclusions formed afterward. The judge began summarizing Harry's answers back to him. Calmly, methodically, each summary fixed Harry's shifting explanations into solid positions. Each agreement locked another piece into place. Harry was no longer moving the story forward. He was being pulled backward, forced to account for his own words. And then the court turned its attention to the past. Not recent events, not Meghan, not California, but a relationship from years before. A chapter Harry had long closed. The court reopened it anyway because it mattered. The articles from that time were part of his claim, and his understanding of them had become critical. The judge began asking about how Harry reacted when those early stories appeared. Harry spoke easily about the pain, the pressure, the damage. Emotion flowed freely. This was familiar ground. Then came the question that froze the room. Did he believe, at the time, that the information had been obtained illegally? Harry paused. And in that pause, the court moved one step closer to a conclusion Harry never saw coming. Harry answered carefully. He said that at the time, he was young. He did not fully understand how journalists worked. He assumed reporters had sources, but he did not know whether those sources were acting illegally. His belief, he admitted, developed later as patterns emerged and hindsight filled in the gaps. That single admission landed hard, because it directly conflicted with his written witness statements. In those documents, Harry had described a clear and frightening belief that he was being targeted unlawfully at the time the articles were published. On paper, he knew. In the witness box, he did not. The contrast was impossible to ignore. This is what the court calls temporal slippage. Memory moves forward, but the claim pulls it backward. Emotional experiences stay vivid. Legal certainty appears later, then gets projected into the past. That projection is deadly in court. The judge returned to a specific article from years earlier, one that caused pain, one Harry remembered clearly. He described how it hurt the relationship, how it created mistrust, how it added pressure. The emotional recall was sharp, detailed, confident. Then the judge asked again, slowly and precisely, whether Harry believed at that exact moment that the information had been obtained unlawfully. Harry could not say yes. He said he did not know. And with that answer, the floor shifted beneath him. If he did not know then, how could he later sign legal documents stating that he did? This was no longer about memory fading. It was about memory being reshaped. The court was no longer listening for pain. It was listening for accuracy. The judge did not accuse Harry of lying. He did not need to. He began identifying a pattern. Harry's memory was crystal clear when it came to emotional harm. But when it came to operational facts, dates, sourcing, illegality, the memory blurred. Not randomly, selectively. That pattern matters. Courts understand memory fades. But they also recognize when uncertainty clusters around inconvenient points. When confidence dissolves exactly where proof is required. That is when concern begins. Harry tried to explain. He spoke about feeling targeted, about sensing something was wrong even if he could not prove it then. He leaned on emotion. But emotion does not substitute for knowledge under oath. And the judge was no longer asking questions to understand Harry. He was testing the reliability of his evidence. Each time Harry softened his language, the gap widened. I think. I believe. To the best of my recollection. In a memoir, those words signal honesty. In a courtroom, they signal risk. The judge began referencing discrepancies between Harry's spoken testimony and his written statements. He called them material. That word changed the temperature in the room. Material inconsistencies are not small mistakes. They go to the heart of a case. At that point, the dynamic fully reversed. Harry had entered the courtroom believing the press was on trial. Now his own testimony was under examination. The emotional shield he had relied on no longer protected him. Sympathy evaporated. Precision took its place. The judge explained that when a witness gives evidence under oath that appears inconsistent with prior sworn statements, the court has a duty, not to punish, but to protect the integrity of the process. That duty requires scrutiny, and sometimes escalation. Then the judge used a word that never sounds loud, but always lands heavy. Concerns. In legal language, concerns are a warning. They mean the court has noticed something it cannot ignore. The judge stated that the inconsistencies raised concerns about the reliability of Harry's evidence on key points. Harry sat still. No outburst. No visible reaction. But the room felt different. Narrative protection was gone. Status was irrelevant. This was about truth under oath. The judge clarified something crucial. Perjury is not about being mistaken. It is not about confusion. It is about knowingly giving false evidence on a material matter. By highlighting the gap between written certainty and spoken uncertainty, the court was signaling something dangerous. Either Harry had overstated his knowledge in writing, or he was retreating from it now. Both options carried consequences. The judge did not accuse. He did not conclude.
He paused.
And in that pause, a new possibility entered the frame. Referral. Not a verdict, not a charge, but an acknowledgement that the issue might extend beyond the civil case. The courtroom went quiet again. Harry was no longer fighting newspapers. He was facing the weight of his own words. And the question now hanging in the air was no longer about privacy or intrusion. It was about whether the truth he told the world could survive the law. The judge did not raise his voice. He did not accuse Prince Harry of anything directly. He did something far more unsettling. He shifted from questions to observations. And when a judge stops asking and starts stating, the room listens. He explained that the inconsistencies in Harry's evidence were not minor. They were material. In legal terms, material means essential. It means the issue strikes at the core of the case. The judge made it clear that where sworn testimony conflicts with prior written statements, the court has a responsibility. Not to dramatize, not to speculate, but to protect the integrity of the process. Then he introduced the concept that had been hovering silently all day.
Perjury.
He did not say Prince Harry had committed it. He did not need to. He said the inconsistencies raised the question of whether parts of the testimony might meet the threshold for referral. That word sounded mild. It was not. Referral means the matter could be sent outside the civil court. It means prosecutors may be asked to decide what happens next. In that instant, the case changed shape. This was no longer about tabloids or privacy. It was about truth under oath. The judge explained that if there is a realistic possibility that evidence was knowingly inaccurate, the court has a duty to act. Realistic possibility sits between suspicion and certainty. And the judge had just placed Harry's testimony inside that dangerous space. Harry remained outwardly composed, but the stillness in the room was unmistakable. This was the moment where status stopped mattering. Sympathy stopped working. Narrative protection vanished. He had entered the courtroom as a man seeking justice. He now sat as a witness being warned about consequences. The judge clarified the standard. Perjury is not confusion. It is not memory loss. It is knowingly giving false evidence on a material matter. By contrasting Harry's written claims of certainty with his spoken admissions of doubt, the court had identified something troubling. At best, reckless disregard for accuracy. At worst, an attempt to reshape the past to support a lawsuit. The judge did not pull the trigger that day. He left the decision open. He said the court would consider its position carefully. The case did not end.
It paused.
Suspended. But the damage was done. The word referral had been spoken. And once that door opens, it never closes quietly. Harry left the courtroom under a shadow. Not convicted. Not cleared.
Exposed.
And that shadow does not stop at the British border. Credibility travels. If a high court judge signals that a witness may not be reliable under oath, that signal echoes elsewhere, especially in places where trust is foundational, places where sworn statements matter, places like immigration offices. Harry has built a new life with Meghan Markle in America, a life that depends on acceptance, legality, and trust. But trust is fragile. And when a court questions whether a man can separate belief from fact, memory from certainty, that question follows him. This is the tragic irony of Prince Harry.
He fought to control his story.
He told it again and again, across platforms, with conviction and emotion. But in a courtroom, emotion does not anchor truth. Consistency does. And when consistency fails, the story turns on its storyteller. The judge did not decide Harry's fate that day. He did something more powerful. He removed the shield. From that moment on, Harry's words would no longer be protected by intent or feeling. They would be measured against evidence, line by line, statement by statement. The silence that followed him out of that courtroom was not relief. It was a warning, because the question now is no longer whether the press crossed a line. It is whether Prince Harry did. And once that question exists, it does not stay contained. It waits. It follows. And it may be answered far from where it was first asked.